If we could come to order. Welcome to the afternoon Senate Judiciary hearing. We have a lengthy agenda, so we're going to go ahead and get started. I'm going to ask Senator Watson if he'll open us up in a word of prayer. You're Mike 12.
Let's go to prayer. Thank you, Lord, for looking after us. Continue to look over us and keep us safe in these troubled times. Keep us safe in our travels. Keep us safe in your eyes, and let us do your work. Look over us and allow us to express your wisdom, and continue to remember the brevity of our meetings. And in Christ's name I pray. Amen.
And brevity of our meetings. So we're going to go a little bit out of order and start with Senate Bill 143. Before I do that, the sign-in sheets, are there still some sign-up sheets out in the hall, or are they all at the podium now? Where? You look and see, Brad? Make sure I have everybody that wants to be heard on the bill. And while they're looking for that, Senator Tippins, if you want to step up to the podium. We're on Senate Bill 143. And we're working off LC 412820. Is that correct, Senator Tippins?
412820.
All right. The floor is yours.
Mr. Chairman, members of the committee, it's my pleasure to bring you the simplest bill you will consider this entire year. This is literally a one-word bill. I'll draw your attention to line 72 in the bill. This bill should be familiar with you or to you. It was passed almost unanimously in both chambers last year, and it dealt with the lien law. And in the process last year, it dealt with the affidavit of non-payment, and there was an oversight, and everywhere that it referenced lien, that was supposed to have been stricken, and the word affidavit inserted, or affidavit of non-payment, as would be appropriate in the context of the sentence. There was one oversight on line 72, and the word lien was left in, and affidavit needs to be there. That's what this bill does. It replaces the word lien with affidavit on line 72. That's the sum and substance of the bill. Nothing changes the operation of the situation of a lien at all.
Any questions for Senator Tippins on Senate Bill 143? Anybody want to be heard on this bill? I don't have the rest of the sign-up sheets. All right, do you have a question? You want to make a motion?
Ready for motion?
Hold for a second. Senator Watson, I recognize you for a motion.
Yes, I'd like to make a motion of due pass for LC 412820, Senate Bill 143.
Motion due pass by Senator Watson. Do we have a second?
Second.
Second by Senator Kirkpatrick. Any discussion? All those in favor of the bill, please raise your hand. Any opposed? It passed unanimously. Thank you, Senator Tippins.
My thanks to all of the committee. Thank you.
Okay. Okay, thank you. All right, going back on the agenda, we're at Senate Bill 85, Senator Albers. And Sky is actually passing around a new summary on this bill. Let's make sure we're all on the same LC number. What LC number do you have, Senator Albers?
I've got 41292S.
2992S?
Correct.
All right. Everybody have that version in their folder? All right, the floor is yours.
Thank you, Mr. Chairman, members of the committee. I first want to begin by thanking you, Mr. Chairman, as well as Subcommittee Chairman Kennedy, as well as all the folks in your office for helping us out. This bill has been worked on and perfected by the help of many folks, including the Governor's Office, Lieutenant Governor's Office, and many of you here. And I'm also proud to have the Gruber family with me today, and they will speak in a few moments if that is okay with you, Mr. Chairman. Senate Bill 85, the Max Gruber Act, is named in honor and in memory of Max. And I'm going to let his family talk about Max and his circumstance and situation. But it's a real honor for me to bring this before you and to hopefully make this the law of the land in Georgia. Relates to hazing. And hazing happens, unfortunately, a lot of times at our collegiate level. And that's not an indictment on any one group or organization. I myself was in a college fraternity. Both my boys were. I was in the band. And I've seen good and bad. But fraternities, sororities, clubs, and other groups are genuinely good. But there are some bad actors out of there, and we need to protect our young people. So this bill does several different things. The first thing it does is it defines hazing in more detail, which you'll see in the second section of the bill, and what that does, right? So there's a difference between an individual doing something on their own or being forced or coerced into doing things. And I'm not going to read each line of the bill, but it's pretty straightforward of them then incurring some serious physical injury, bodily harm, or even loss of life. And if you continue through the bill, this specifically exempts a couple of groups that are covered under other areas or regulations. Those two of those groups I want to mention specifically are NCAA sports, because they are governed under their own entity, as well as ROTC type programs, which are governed under the Department of Defense. Continuing through, this could be a public or private university. Obviously in Georgia we have many of both, very celebrated. And it continues to go on and talk about what the punishment would be for creating a different level of crimes, for making sure that people are being held accountable. It also goes further to make sure we're getting at either the chartering national organizations or the alumni boards. I will speak from experience. I myself was on the alumni board of my fraternity chapter at the University of Louisville. Took that job seriously because our job was to help to provide oversight and governance for those young men, just like we do in sororities and other clubs. But we need to make sure that they themselves are being held accountable. So in this legislation, we actually allow the Attorney General to seek civil penalties for those who are habitually letting those things happen and are asleep at the wheel. We want to make sure they're covered. But also, and this is really critical, is we want to reward those young folks who are doing something about a bad action in progress. They see something, they say something, they stop, they call the authorities. We want to give them the protection and the support to act. Ultimately, we don't want to ever have to prosecute this because it doesn't happen to begin with. And I think when you hear from the Grubers today, you're going to see how they've made it their life mission to go around and to educate people, to show them why we can do this better. So through this process, again, there's a series of penalties and protections. And the last, and I think is an important part, is I call it the truth in advertising part of this bill. My younger son is in college right now, right? And you want to be able to look online and see, did some of these organizations have a difficult history and problems, and how long ago? So when things are happening, nothing's getting swept under the rug, right? It's an open and transparent process. Good decisions can be made. Again, ultimately, it can help people learn and be safer, which is what we all really want for our young folks. So that's a very high-level summary of the bill. And if I could, I'd love to turn it over to the Grubers and then maybe come back up for questions if that's appropriate, Mr. Chairman.
That'll be fine.
All right, I'm going to begin by asking Max's mom, Miss Rayanne Gruber, to come up, please.
Good afternoon. I appreciate you all taking the time to hear us today and talk about this very important bill, Senate Bill 85, the Max Gruber Act. Our son Max died 3.5 years ago because of hazing in his fraternity at LSU. Max was like any other young man starting off his college career. He had just graduated from Blessed Trinity Catholic High School. He dated this beautiful girl for all 4 years of high school. He is very close to his younger brother Alex, and he has a little sister, Lily Kate. He had many friends, and he enjoyed playing all the rec sports, baseball, and he coached baseball. He coached basketball, his sister's basketball team. He was an avid writer, and he wrote for a sports website in high school. He went to LSU because he liked the journalism program there, and he knew he had a lot of possibilities ahead of him. He decided to join a fraternity so he could meet people and get involved at a really big school. Max died 29 days into his freshman year at 18 years old. because of alcohol hazing in his fraternity. Max was forced one night, in less than an hour and a half, to drink copious amounts of alcohol because he didn't answer questions right about his fraternity history or recite the Greek alphabet correctly. He was forced to take pulls off of 190 proof grain alcohol called Diesel. Max's blood alcohol level was a .495. Max was humiliated, he was screamed at, and at the end of the night, after, again, 1 hour and a half of drinking all that alcohol, he was left on a couch where Max, a few hours later, died. They noticed, the brothers, that Max wasn't doing well, that he was turning blue, that he was having trouble breathing, but they were more concerned about themselves and getting in trouble than in actually saving Max's life. From our tragic experience with hazing and all the tragedy that it ensues, we know strengthening the hazing law here in Georgia will save lives. I know our education that we've been going across the country for the last couple of years and speaking to universities and to national organizations will help change lives. It has already helped change the hazing culture that's out there. By strengthening our already existing hazing law here in Georgia, we can empower these young adults to do the right thing, to use the law as a deterrent to end hazing on their campuses and in their schools. Georgia must be proactive in harsher hazing laws. Do not let a tragedy like ours be the reason Georgia must change the law. Get ahead of it, and let's start helping these young adults use it to end a horrible culture that should never exist. Hazing is not an accident. Max's death was not an accident. Hazing is intentional, and it is fatal. We all need to take care of each other, look out for one another, and speak up when we see something is wrong. It will save someone's life, and it could have saved Max's life. So I want to save other lives here in Georgia. Thank you for your consideration. We appreciate you voting yes to Senate Bill 85. All of our children's lives are worth it.
Thank you, Ms. Gruber.
Thank you.
Hi, my name is Blakely. Thank you for having me. As Rayan said, I was Max's longtime girlfriend, and just less than a month after both of us left for college, different states, he died. Hazing has altered my life completely. I felt like I was widowed at the age of 18. I was diagnosed with post-traumatic stress disorder, and I spent every waking moment of the day wondering why this had to happen to him and why it had to happen to me. Hazing is way too common among college students. Being one myself who was previously involved in Greek life, I know this to be true firsthand. The horror stories I have heard from my own friends, my acquaintances, or just random people that will come up to me because they know my involvement on campus is absolutely scarring. Not everyone who gets hazed will have the same fate that Max has, but we never know when that could happen or if it will happen. And most of the time, things will happen to these people, but just because they don't die, we don't hear about it. The amount of people I know that have been sent to hospitals, been arrested, have dropped out of school altogether is just way too high of a number for just joining a club. Our human lives are way too valuable to be gambled away for any sort of organization, and students should be able to have peace of mind when they choose an organization to see the risks and benefits of what they're getting themselves into. And they should also know that their state legislators take their safety so seriously that those who choose to disregard human life in hazing will be punished. Our Georgia community has suffered a heartbreaking and preventable tragedy when Max passed. Hazing is a life-threatening safety issue that has not had enough attention being paid to. If we pay attention, we can save lives. And in memory of Max, I ask for your support in passing the Senate Bill 85.
Thank you.
Hi, my name is Steve Gruber, and thank you so much for your time today. The day we returned home after Max passed away in Baton Rouge, Rayanne went up to his room. As she spoke earlier, he was an avid writer, and she looked for a journal that he had written, and she found another one and opened it up directly to a page where Max had written, and I want to read his quote. He wrote, "God works in funny ways. He does bad things sometimes because in the end they are good. Something bad can happen, but it may happen because it will make you better. He does bad to ultimately create good." Once we read that, we knew our path in life was to work very hard to bring an end to hazing. We started the Max Gruber Foundation, and since then, my wife predominantly and I have spoken to over 100 universities in our efforts to try to educate young adults to the dangers of hazing and just how wrong it can go so quickly. We often talk about the laws when we discuss with the students, and we want to make sure that it has an impact. And we found that when we have felony hazing laws in a state, that they're listening to us much more strongly than they are when we have more inadequate laws in the books. So we let the students know that these laws are there to protect them and why, and the law needs to be strong enough to act as a deterrent. The intent is not only to deter the bad actors, but more importantly, to empower the good actors to stand up and do the right thing, and if they see something, say something and make it end. Senate Bill 85 is the best and most well-written hazing deterrent in the country. It sets the bar for all other states without felonies, hazing laws to look to rise to. Please pass Senate Bill 85. It protects our young adults and children and serves as a powerful tool to end hazing in our state. Help us create something good out of the horrible tragedy that our family has endured. Thank you.
Thank you, Mr. Gruber. I want to thank your whole family and obviously you, Senator Albers, for your work on this issue. I know you've been working for some time trying to get this passed in Georgia, and persistence is what it takes. And I know hopefully the bill has gotten better along the way as we've worked on it. I just appreciate you guys not giving up and staying with us as we try to make sure we get this right. Do you have anything else before I take questions, Senator Albers?
Mr. Chairman, I would just like to say that just 3 days before Chairman Kennedy's subcommittee meeting, I was awarded to one of our colleges right here and a club right here. I'll remain nameless right now because it's now under investigation. Locked 7 young men into a restroom and said there's 100 beers in the bathtub and nobody can leave until every one of them is drank. 7 to 100 of 18-year-olds. Thank God a couple of them thought better of that and they left. However, this is something that's real and does happen. We are not indicting the system at all. In fact, we're going to celebrate the fact that most organized clubs, sororities, and fraternities have higher graduation rates, do very good things, a lot of good service hours, and we want to celebrate that, but we also want to have protections at the same time. But I would be honored to yield for questions. There are one tiny word Scrivener error that I will bring to your attention at the appropriate time.
All right. Senator Parent?
Actually, just a comment, Mr. Chairman, is that okay? Okay. First of all, I just wanted to thank you, of course, Senator. You know that I support your bill. Thank you for your hard work on it. Thank you to all of you for being with us. I'm so sorry for your tragic loss. I also wanted to just quickly commend you for the work that you've done with the foundation, talking to universities, and mention that just a couple days ago, my husband, one of his college roommates, his son has now pledged the same fraternity that my husband and his roommate were in, which is SAE at Wofford College. They got a huge, long email laying out all of the accomplishments of all the members from the faculty advisor. Their brothers, like 2 days later, I mean, it went in, and it was, my husband was just like, wow, things have changed. I mean, nothing like that would be happening without the efforts of you know, these conversations that you and people like it are having, because it was also vastly different than anything that I would have seen when I was in college. So just thank you so much, and I'm so sorry that you had to lose your precious son and boyfriend to make this difference in the world. So that's it, Mr. Chairman.
Senator Kirkpatrick?
Yes, thank you very much for bringing the bill. Thanks to the family for coming to speak to us. I just wanted to highlight lines 96 through 111. This is very reminiscent of the bill that we passed related to opioid overdoses, and because people were afraid to call 911 because they were afraid they'd get in trouble, and so they'd dump their overdose friend at the ER and drive off, and that has saved countless lives. So I really commend you for putting that in the bill.
Thank you, Senator.
Any other questions for the author of the bill? Thank you, Senator Albers.
Thank you,
We
Mr.
have
Chairman.
one person signed up to speak on the bill, Jill Travis with the Georgia Association of Criminal Defense Lawyers.
Good. Happy New Year, actually. I haven't seen you this year.
Good to see you in person.
Yeah. Good afternoon. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. Our heart goes out to the Gruber family for this tragic crime. What we want to make sure of, though, is that the bill is as narrowly tailored as it possibly can be. And a couple concerns we have is, we know that brain science is involved with young adults, right? That's why in this bill, I think you see that express consent is not even a defense to this action. So it makes us wonder, what about the brain development of the kids that are involved and the students that are involved in this? Should this be a felony punishment? That's a question for you to decide. The other issue is it's a little hard to talk with all these masks on. I'll take one of them off. The other issue is force, and what is the definition of force? How broadly is that construed? Is it verbal cajoling? Is it pushing alcohol to someone? It's any element of force is the language that's used in the bill. I don't think I have the most recent substitute, but there is some vagaries that still remain in the bill, and those are some of our concerns that as this goes through the system. Of course, we hope that the enforcement of this is done with wisdom, but we can't help but bring to your attention some of our concerns with regard to those matters. Thank you.
Thank you, Ms. Travis. Anybody have any questions for her? Seeing no questions. Anybody else who wants to be heard on this bill? At this time, we'll take a motion. Senator Hatchett, sorry, I was looking down.
Move do pass.
Move do pass by Senator Hatchett. Is there a second?
Second. Second
by Senator Kennedy. You mentioned there being one area you want to address in
Yes.
the bill.
If I could, Mr. Chairman, just direct you to lines 41 and line 154, both at the very same place. It'd be the last word on line 41, the word than, after entity, change it to from. Just, again, a Scribner's error, and it's the exact same place on line 154. Again, just changing than to from.
Does somebody want to offer that amendment for Senator Albers? Senator Parent offers the amendment of changing the word than to from on lines 41 and 154. Do we have a second? Second by Senator Rhett. Any objections to the amendment? It passes. It's adopted. Senator Hatchett, was your motion do pass by committee substitute? Yes. Okay. All those in favor of Senator Hatchett's motion, please raise your hand. As amended? Any opposed? It passed unanimously. Yeah, as amended.
Thank you,
Thank
Mr.
you for
Chairman,
your
members of
work.
the committee, and fly IMAX.
Yeah, and thank you all once again for being here. Appreciate you. It's too early in the day for me to use an excuse about messing up the lingo, but. Next bill on the agenda is Senate Bill 78. Senator Jones, you can do it from your seat or up there. Okay. Okay. And we are working off LC 412977S. Is that correct?
That's correct, Mr. Chairman.
All right, the floor is yours.
All right, this is an extension of current law, actually, when we talk about what's called image sexual abuse. Currently, if you transmit or post sexually explicit conduct of an adult, including a false image, when the transmission is cause for harassment or causes financial loss, the first lifetime for that offense is a misdemeanor. Second is a felony, but the first lifetime for that offense is a misdemeanor. So that is current law today. What this bill actually does, it says that if a person does the exact same action, which is transmit or post sexually explicit conduct of an adult, including false imagery, when the transmission is harassment or causes financial loss, but they post that basically to a web page or a website which is basically a pornography website, and one that advertises itself as being a pornography website, then that first offense would be a felony. Basically, the reason why we're doing this is because the mental state and potential harm that exists by posting onto that particular website is so much greater than what I believe we initially kind of thought about as our quote-unquote normal image sexual abuse. And you almost hate to use those terms, but in reality, in criminal law, we recognize that there are crimes and there are different gradations of crimes. So when we usually may think about image sexual abuse, it might be someone posting on Facebook or someone sharing with their friend. And so we say that that's going to be a misdemeanor. But when you post that information and you post that onto a pornography site, basically what you're doing at that point in time is actually trying to literally almost destroy the particular person that you did that with. There are 129 million hits per day on pornography sites, 3.5 billion per month. The population of the world is only 7.8 billion. Most of these are geared towards women. 96% of all deep fake posts are pornographic, and they're also mostly of women. Why this actually came to light, you may say, why did this come to light that we're using this differential? Well, basically, one of the areas that came to light was a New York Times Magazine front page article talking about the children of Pornhub, December 4th, 2020. And Pornhub is one of the larger pornography sites. And what that talked about was the fact that you actually had children and those who were close to being of age on this particular site. And it also talked about what we normally call revenge porn. So this was a New York Times article that came out and started showing light to this. Also, in the Guardian magazine, there was an article written about this same issue that's recently been coming to pass that says that Pornhub should forget the coronavirus because they were doing some charity events for coronavirus and focus on its new pandemic, which is revenge porn problem. That was March 14, 2020. What was going on was lately many women, unfortunately, have been finding themselves on these pornographic sites. It has caused persons to go through massive depression, also potential suicide. There are many articles that basically print this out. And I picked those two because those were the two leading articles that talked about how this is becoming an issue. It is such an issue that the largest pornography site, which is Pornhub, actually said that they wanted to now verify all of their videos. When they made that rule, and it all comes about because of this quote-unquote revenge porn which is going on, this rule was not in existence under our current law. So our current law that just says if you just post to a regular site, whatever that may, if you want to call something a regular site, this rule was not in place. After all of these articles and after it's become known nationwide about this new sort of image sexual abuse, Pornhub decided that all of their videos had to be verified. When they did that, they lost over 5 million videos. 5 million videos were lost because they could no longer be verified, and it's projected that many of those were because they were quote-unquote image sexual abuse videos. Also, a new rule that went into effect, MasterCard and Visa would no longer allow their products to be used on any of these particular websites. They did not have that rule until this started coming to light. So MasterCard and Visa would always allow persons to use that. This new rule came into effect only after the issue of revenge porn or image sexual abuse started to come to light. And so they've now done that rule. Pornhub has actually responded positively to a lot of these issues, but you actually have some of these web pages that actually advertise themselves for the sole purpose for quote-unquote image sexual abuse or revenge porn, such as myex.com or Telegram, which actually sent out a message to all of its providers saying that they are not going to process any requests to take down illegal material. So they're actually advertising themselves to put that kind of material up. Senator Josh Hawley on the national level just recently in December is now trying to pass a new law to allow persons to sue online websites. All of these things have come about over just the last 1 year. And so he's trying to do that. That is a bipartisan bill dealing with the 1996 Communication and Decency Act. And so why make it a felony? It's simple because we say that what you're attempting to do now goes beyond just misdemeanor treatment. And it's similar to where we say that if you commit theft, if it's $500 or lower, it's a misdemeanor. But at 501, it becomes a felony. If you have marijuana and you have up to 1 ounce, it's a misdemeanor, but over 1 ounce, you become a felony. So we do this consistently within the law. We look at the same conduct, but we say, now, when you go to a certain point, a certain line, that conduct has now gone beyond misdemeanor and now into felony territory. There are 9 states actually that do this as a felony now. They do not do any differential at all. So I actually believe that this particular law does a balance to where you still have, and I hate to use the term normal, the normal image sexual abuse is a misdemeanor, but then there's a line that we will be drawing saying that then it will become a felony. So it actually balances it out to some extent. And I do use the term image sexual abuse. We normally call this revenge porn. But most commentators now say that's inaccurate because revenge actually takes into connotation that you're retaliating against something that's been done wrong to you. And in reality, in this circumstance, nothing has been done wrong to anyone other than the fact that somebody has broken up with somebody. And then also normally when we think about pornography, it's consensual sex, even though we understand there can be debates about that, but it's consensual sex, and there's nothing consensual about a person placing this onto a website such as this. And so that's why we actually use the term image sexual abuse and not just quote unquote revenge porn. And that is basically the gist of the bill, Mr. Chair, and I'll be glad to take any questions.
Any questions for Senator Jones? All right, thank you. We do have one person signed up to speak on the bill, Taylor Hawkins with the Family Policy Alliance. Mr. Hawkins, good afternoon.
Good afternoon, Mr. Chairman. Appreciate your time. My name is Taylor Hawkins. I'm a policy associate for Family Policy Alliance of Georgia. Our deputy director spoke in favor of the bill last week, but I just wanted to reiterate our support for this bill, give you a very brief testimony of someone who would wish to remain anonymous for her privacy, but just to give this a little more personal character. This young lady was an 18-year-old senior in high school at the time of this story. A friend of hers took some photos without her knowledge at a sleepover and sent them amongst a friend group. Young man with a bad reputation in her school obtained that photograph and posted it online with comments insinuating many untrue things about a relationship with her that had not happened. It ended up through some means being posted on a pornographic site, which some male schoolmates then shared in the school. This was taken by virtually the whole of her schoolmates as verification that what the young man had posted on social media was in fact correct. She went to sleep that night with nothing wrong, looking forward to her graduation and college career, and woke up with everyone in her life having seen these photos and many of them believing and ridiculing her for what they thought she had done through absolutely no fault of her own. Her reputation was immediately ruined among her friend group because of what this young man had done. She was ostracized in all of her social circles. She dropped out of her school, left her church groups, refused to finish high school or begin college, and went into complete depression and came very close to suicide. Thankfully, she has sought counseling and is still with us today, but her family was forced to move to a new house, find a new school, and her college career was delayed, not to mention her personal trauma as her world fell apart, all because this 18-year-old young man knew there will be little or no real accountability for his harassment. This is an extremely important issue, one that touches many innocent lives, so I thank you for taking the time to hear this bill, and I would ask that you vote in favor.
Thank you. Any questions for Mr. Hawkins? Thank you very much. We do have one question.
No question. I've just been set the proper time if there's no other questions. I'd like to make a motion.
Anybody else want to be heard on the bill? I'll recognize Senator Rett for a motion. Move to pass by committee substitute.
Second.
We have motion to pass by committee substitute by Senator Redd, a second by Senator Parent. Any discussion? All those in favor of the bill, please raise your hand. It passed unanimously. Thank you very much. All right, we do have another meeting at 3:15, I was informed, after us, which some of y'all are on that committee as well. And so we do have a hard stop today. And so I'm going to continue on the agenda, but make sure that everybody that's come up here to speak at least can be heard on their bills today. And somebody take some of these out of order as we go for the next 20, 25 minutes. Next bill on the agenda is Senate Bill 163. And I'll be brief in presenting the bill and let the folks that are up here to testify speak. I put this on for a hearing only, so we can continue to work on the bill this week. With Senate Bill 163, we are trying to address an issue we may have in our state, or will have in our state, with jury trials or criminal cases once the public health emergency has expired. It's important to know there's statutory speedy trial rights in our state where we've addressed how trials are conducted or how speedy trial demands are filed. And there's the constitutional speedy trial protections. We cannot waive constitutional speedy trial rights. And our current law is viewed as something that obviously doesn't go all the way on that issue, and is a very generous law in how speedy trials are addressed in our state. And as you'll see with Senate Bill 163, we're setting forth a process where, beyond the public health emergency, based on findings from the Chief Superior Court or state court judge of a circuit can actually waive the speedy trial statutory protections on a temporary basis as we try to get jury trials going. It's viewed this way: we either have some protection like this, or we're going to have to let people out and not try cases. If you don't do something this session on this issue, then you're going to see potential for folks to take advantage of our current statutory protections that we have with speedy trial demands. And then you're going to have a situation where prosecutors and judges are trying to figure out which cases they're going to let go. And so I think it's a very important thing that we address this year. Briefly on the bill, then I'll turn it over to people who can't be here to speak, and we'll finish this up another evening this week. You'll see on page 3, we set forth the findings of what a judge is supposed to look at when it comes to whether or not they find it's impractical for speedy trial demands to continue in their circuit, or waiving speedy trial demands. You get to page 4, we put what must be in the order, what a judge must find if they're going to suspend statutory jury trial rights in a circuit. Included in that is a plan to actually resolve cases. What we don't want is for some circuits to take advantage of the ability to not move cases. Not that anybody would ever do that, but if you don't have some protections in here, this could be abused, and you could see a judge that decides, or a prosecutor, or whoever's involved, decide they are not going to move cases in a fast enough way, because we're constantly trying to balance the right, obviously, of those that are accused and those that are sitting in jail waiting for a trial, versus the public benefit of making sure we can actually try cases. Lastly, speaking of that, we have a couple safeguards in the current draft of the bill. One is this expires, as you'll see on line 124, line 125, the total period that a court could, or circuit could do this only lasts twice the total duration of the preceding judicial emergency. And lastly, you see, starting on line 130, a direct appeal that would go to the Chief Justice of the Supreme Court on their own accord. So without waiting for the appeal process, if you have a local Chief Superior or State Court judge that is not handling this properly and somebody wants to challenge that, then they have a direct line to the Chief Justice to possibly overrule a local court. As we've seen during the pandemic, the role that our Chief Justice plays in setting the policy, if you will, for the bar in our state. And once again, on lines 137, 138, we are confirming here, as we can't do, that we're not waiving any claims to the constitutional right for a speedy and public criminal trial. Somebody wants to challenge this, they can still file suit on that issue, of course, regardless. So with that, unless somebody has questions for me about the bill before I turn it over to the people here to speak. Senator Counsel.
If I could just ask you one, the thing that keeps troubling me about this is somebody can be held in jail, allegedly presumed innocent, and not have an active opportunity to have a trial. Does this consider in any way that perhaps the courts would have to grant bond if they're going to deny the speedy trial?
I don't believe it does. I think it's a good question for the judges that are here. It's definitely something we have to consider, because that's who's getting the burden in this. Really is that person that's sitting in jail, can't get out, waiting for a trial. And obviously sometimes length of time before your case is tried can be a benefit to a defendant, but you have a statutory and a constitutional right to have that case heard in a certain time period. And so I think that's a good question we need to ask. And if it's not built in, if there's any way that could be a consideration as well.
Okay, thank you.
Any other questions for me before we turn it over to some of the folks that want to be heard? I'm going to start with Chief Judge Brasher from the Atlanta Judicial Circuit.
Good afternoon, everyone.
Good afternoon, Judge. We turn you
Very much for the opportunity to come to you all and speak this afternoon. 2 points that I want to address. First, really goes directly to the question that was just asked. Primary purposes of this bill, first, is to allow for the orderly administration of justice when we come out of the pandemic. Because the reality is that if we don't have relief regarding the speedy trials, we're going to end up trying 3-month-old cases before 3-year-old cases, because there will be demands filed in those cases and not in the older ones, because someone can't file a demand. So this will allow us to address those cases back to front. And in fact, as Senator Strickland pointed out, the statute will call on the judges who enact these plans to set forth how we're going to do it, to set forth the prioritization, which will include trying oldest to newest. So that's the first thing. The second is, again, to highlight the safeguards that are built in to this legislation. First is it only applies in the wake of a statewide judicial emergency. So when we enacted the statewide judicial emergency bill a number of years ago, we hoped we'd never use it. Here we are, a year into it. This would only apply in the wake of a statewide judicial emergency. The second is that it requires evidence and fact-based reasons for enacting, or excuse me, for passing the order that would allow for this tolling or period out of time for the speedy trial demand. So in other words, we've got to show why, based on evidence, based on facts, enter written findings of fact and certification, and set forth a plan for how we're going to get out of it. Numbers-based plan, evidence-based plan. And the third, again, as was pointed out, is that this statute in no way would affect the constitutional speedy trial guarantees under the Sixth Amendment. And so based upon those things, that's what we're focusing on, again, is the orderly administration of justice. In Fulton County, when we started last year, we had roughly 2,800 people in the Fulton County Jail. 10% of them were unindicted. Now 50% of those of those inmates are unindicted. All those cases are going to be indicted in short order. Without this kind of protection, it would be foolish for many of those folks not to file a demand for speedy trial. They would have the ability to have their case resolved in short order, one way or the other. And so we would then be forced to try cases that are 3 months old as opposed to 3 years old. That's the orderly administration of justice issue. Also, if we do not have this protection in place, those folks who are sitting in jail, ultimately, if we have to try the newer cases first, those older cases will be lost on a constitutional speedy violation. So we're caught in that Hobson's choice of having to decide, as the chair pointed out, which cases are going to be lost to that. But most importantly, it makes sure that those folks who've been in jail the longest get their cases tried first. So again, those are the points that I wanted to make, and I'm happy to answer any questions if anyone has any for me.
Senator Calzert.
Thank you, Mr. Chairman. I hate to be the only one questioning, but I have a small percentage of my practice that deals with criminal defendants. And
yes, sir.
I'm stunned by that stat that 50% of the people in Fulton County Jail have not even been indicted.
That's right.
So they're indictable offenses, which are serious offenses, and they're being held in jail without even bond or being given a trial?
Yes, sir, because of the statewide judicial emergency order.
Why aren't the judges letting these people be innocent and, till proven guilty, and at least let them continue with their jobs and, be members of society till they're proven guilty?
And I can tell you, Senator, that there have been bond hearings. I've conducted hundreds of bond hearings during the pandemic. Last statistics I saw is that there are approximately 12,000 defendants whose cases are unindicted, and of those, about 1,400 are in jail.
So how are those cases brought? By just an arrest by an officer, or by accusation, or what's the mechanism to have them landed in jail and not yet had scrutiny from a grand jury?
Based on a warrant usually from a police officer.
Any other questions for the judge?
Thank you all very much.
All right, thank you. Next, we have Judge Brian Amaro, the Chief Judge from the Flint Judicial Circuit, Henry County.
Thank you, Senator Strickland. I just rise to strongly support this legislation. I think ultimately this comes down to whether or not we're going to decide cases on the merits or whether they'll be dismissed. And otherwise, I support everything that Judge Brasher has said. I believe that he is correct in his evaluation of the overall structure of the statute, how it operates, what it means. And I thank you for this opportunity to express my support for the legislation.
Any questions for Judge Amaro? Senator Calzert?
All right, so kind of back to my line of questioning there. If a person is arrested on an arrest warrant just by the investigating officer, and there's time delays or whatever here, and they are released or dismissed, can't the prosecutor still go back and indict up till the statute of limitation runs?
If the case is dismissed at a preliminary hearing?
Yeah, if it's null pros by the prosecution because they can't get to a grand jury or don't have ability to meet it. Are they barred by double jeopardy from bringing that again, or are they still able to indict later and bring justice in the event once the emergency passes?
Well, I think I understand the nub of the question, and if I don't, then I apologize. But ultimately, I think the types of cases that we're talking about, where people have been incarcerated without bond for some length of time, are in a different category. Judges over the course of this pandemic are doing everything that they can do to release everyone that is not a threat to the community. And we spend innumerable hours. We're constantly vigilant in our evaluation of these cases at bond hearings. And what we're trying to do is make sure that only the people who are in jail are the people who are a clear threat to the community based upon what we're seeing. We want everyone out that we can get out of the local jails. There's also a COVID threat by having too many people in the local jails. The sheriffs have made it perfectly clear to us, please, don't keep anybody in there unnecessarily. And we hear them. We support them, and we recognize that, first of all, that people are entitled to adjudication on the merits as criminal defendants. We want that. We want a fair trial as soon as possible. And we want to release as many people as we possibly can to alleviate the issue that arises at the jail. And so I think that you'll find, if you do a careful scrutiny of the work of Superior Court judges all across the state over the course of the last 10, 12 months, is that there are fewer people in jail on less serious offenses than at any point in the last 20 years. We're doing everything that we can, Senator, to make sure that the only people that are kept in jail present a clear threat to the community. And that's ultimately how I view it. I know that's how many of my judges view it. And I thank you for your question.
Any other questions for the judge? All right, thank you.
Thank you.
Next on the list is Pete Scandalakis with the Prosecuting Attorney's Council.
Thank you, Chairman Strickland. It's always a pleasure to be in front of this committee, and especially to be subject to a thorough and sifting cross-examination by Chairman Calzert over there. And I'm used to that, so I'm prepared for any questions he gives. On behalf of the Prosecuting Attorneys Council, on behalf of the DA's Association, we support this legislation. And it's an extraordinary bill. There's no doubt this is an extraordinary bill, but this is an extraordinary time. I recently did a poll of all the DA's office, 49 judicial circuits. Of those 49 judicial circuits, I had about 42 respond. And the question I asked them is how many undrawn cases, and by undrawn cases, I'm talking about a case in which a case file has been submitted to the DA's office and it has not been accused, it has not been indicted. They didn't have a grand jury, they couldn't come in, or they haven't had time to review the file, to screen it out. And one of three things can happen. Well, more than one of three things. The case can either be dismissed after it's reviewed. The case can go to a pretrial diversion, accountability court. Case can be accused by an accusation, or you can take it to a grand jury. This was in December. There are 60,000 pending cases, undrawn cases, sitting in DA's offices as of December. Those do not count the number of cases in which there have been indictments already filed or accusations already filed, and they also doesn't count the number of cases that were on a trial calendar when we had to shut the courts down. That is, we could not bring in grand jurors, we could not bring in jurors for jury trials. So those cases were pre-pandemic. We now have what we call post-pandemic. This is an extraordinary bill. This calls for an extraordinary time because you don't want to just have cases dismissed without listening to the merits of the cases. There's nothing I can add to what Chief Justice Brasher said or Judge Amaro. There's really not much I can add. I can to try to answer Chairman Calzert's concerns. I know the DAs and the judges have been working to have as many virtual hearings as possible to move cases out of the jail. And those people that have been sitting in jail have received priority to try to get bonds and things of that nature. The ones that in Fulton County is a good example. The ones that are in Fulton County now with either a high bond or no bond are the ones that pose a danger to the community, have committed some violent crime, may flee the jurisdiction of the court. But the judges are aware of the situation, as are the DAs. And so that's why I rise here to support this bill. And I'll answer any questions if you have any questions.
Any cross-examination? Oh, you scared them off.
This is the first time I haven't been cross-examined by Chairman Calzert.
Sit down now.
Thank you so much.
Thank you. Next, we have Jill Travis with GACTL, Georgia Association of Criminal Defense Lawyers. And she has some notes that were shared in all of our folders as well.
Good afternoon, members of the committee. Thanks for hearing me again. We are concerned, very concerned about this bill. Public health orders are designed to slow a pandemic, not to give the government an advantage in criminal trials. When we talk about why do you file a speedy trial demand, somebody's in jail. They're charged with a crime. They're innocent. They can't make bond. They can't make it because it's set too high or it hasn't been set. There's nothing to lose. There's nothing to lose for them. That's another reason why people file speedy trial demands. The offer's super high. We filed a speedy trial demand to make the case, maybe there's a hole in it somewhere to get a better offer. What about there's bad facts that the prosecutor hasn't had a chance to investigate? One of our members had a case where the person was charged with aggravated stalking. It was based on a violation of a TPO, an unlawful TPO taken out by an ex parte. The TPO had to be dismissed, but it didn't take away the aggravated stalking charge. Aggravated stalking means he stays in jail, no bond. File a speedy trial demand, and that gets the prosecutor looking at it. When you talk about prosecutors looking at cases, they can file accusations. Some of them are filing accusations, some of them are not. So one of the other things that comes into play with a speedy trial demand is what are the terms of court? Some terms of courts in some jurisdictions are 4 months, some are 3 months, some are 2 months, some are 6 months. It varies across the state, and I had an example to give you, but I know you're short on time, so I'm going to skip that and say that there's A couple of things that I really want to focus on. First, that there be a sunset provision in this bill. This set of circumstances that are contained in your bill that has what's happening now as far as circumstances may not be the circumstances years from now. And to have this perpetually in place, we think is not wise. If you look at the language that we've provided, the drafts at lines 51 to 53 are our suggestion for a sunset for this proposal. We feel like the application of this is too broad. When you talk about the totality of the circumstances, what has to be happening is this is because of the pandemic and then the situation after the pandemic. There has to be a tie. So if you look at the sample that we have on lines 8 through 12 of our language, you notice that we use it's after a judicial emergency order suspending or tolling the requirements has expired if compliance with the requirements arising from the preceding judicial emergency is impractical. There needs to be a tie of the before and the after. What about the factors to consider? What is impracticable? What does it mean to be impractical? Well, one big problem in this bill, if you look at line 75 of the bill, at line 75 you see the word or. That means any of those features, any of those factors can be the one feature that allows a chief judge to enter a suspension of speedy trials. Well, one of the factors is the limited availability of judges, prosecutors, public defenders. Y'all been to appropriations? Have you ever been to appropriations where you haven't heard law enforcement, prosecutors, judges complaining about not having enough staffing? That one factor alone is enough for the judge to shut it down, no more speedy trials. So we know that there were a lot of cases back in March, and we know that there's still a lot of cases now. We know that this body has already passed Senate Bill 9 because that was the Augusta Judicial Circuit. They need more judges. The Blue Ridge Circuit needs more judges. Then just think about the AJC article last week where Fannie Willis was quoted as saying, and then there's the 100 of brown file boxes stuffed with paperwork from upward of 10,000 cases. Some originating as far back as the 70s. They were stacked 7 and 8 feet high, hallways blocking. A physical manifestation of the mountains of work that awaited the veteran prosecutor trying to turn around what had become a dysfunctional workplace. Is the management of a district attorney's office enough to stop speedy trial demands that are so critical to the defendant? Superior Court Judge Wade Padgett was quoted in a Daily Report article, and he talks about the difficulty with reporting cases, and I'm going to bring your attention to two of the factors, which is the case count and the case clearance count rate. And he said there's no uniform reporting requirement other than the caseload reports due on March 15th. Circuits don't uniformly use the same case management systems. This is from a Daily Report article on January 12th. He said, candidly, the best way to explain is that every county is different. For better or worse, that's just the way it is. But in fact, his court administrator talked about how they'd actually disposed of more criminal cases than had been filed in that. So staffing alone and these case counts, we don't think should be the issues. We think the number one issue, because we do realize that there could be an avalanche. We don't know that there's going to be an avalanche, but we understand that you have to prepare for the possibility of an avalanche. The number one issue is how many speedy trial demands are there out there? The funny thing is with a speedy trial demand, it's the one pleading you have to file and you have to serve on the prosecutor and the judge that the case is assigned to. So in my mind, there's this red file box over here. That's where the speedy trial demands are kept, and you can keep track of it. So how many are there? The other thing is that how many trial weeks are there? Many of you are lawyers. You know that in some jurisdictions, there are several trial weeks during a term, and sometimes there's only one. Are the judges able to work? I'm not saying that anybody needs to work 24/7, but we're going to have to do something to come out from underneath this backlog, to keep it moving. So the other thing is just, again, with the language of the speedy trial demands, If you look at the language that we've used on lines 13 and 14 and compare it to the language that's in the bill, we say the number of speedy trial demands pending before the judicial emergency and the number at the time when the declaration is made. Isn't that a reasonable comparison? So let's say there were 3 before the emergency and now there's 40. Well, that sounds like maybe there needs to be some relief. But if there were 3 before and there's 1 now, that shouldn't be a reason. We've asked for the timeframes to be a little bit shorter than what is in the proposal in Senate Bill 163. We do have some concerns about, we realize that the bill is written in a way that we're supposed to be able to tell the Chief Justice. We've got some problems with the way Bibb County, for example, is doing this. We don't think that they're operating to the best of their ability. So we call them, I guess, because we don't want to do an appeal. But what does it mean for the Chief Justice to not take action? Is the inaction of the Chief Justice considered to be acquiescence to the delay? How does that come into play with a murder case that goes up? How does that factor in? We know that everybody's going to have difficulty once the gates are back open again, but we know there has to be some way to resolve the backlog. I mean, even private lawyers, you can only take on so many cases. You know, public defenders have to keep taking cases on, but...
Mr. Travis, I don't want to cut you off, but we do have I'm waiting outside. I'll let you wrap up if you can in 30 seconds or so.
I'll do that.
So we'll continue this conversation on Wednesday.
We're just asking that that the factors be narrowed, that they be specific. We've drawn your attention to that. And the other thing is that there be a sunset. And then one of the other pandemic proposals that is out there is House Bill 555, which is to allow bench trials in criminal cases without the objection, or with listening to the objection of the prosecutor, but it allows the judge to go forward with it. And we think that would let more trials go forward. Happy to answer any questions. Thank you for your time.
All right, thank you. You have a question from Senator Parent?
Thank you, Mr. Chairman. Very quickly, you've given us this document. Ms. Travis, this is your suggestion, and your organization would be amenable to the bill with these changes? I just want to make sure I'm clear.
Yes.
Okay, thank you.
I will tell you, it's streamlined. I mean, there's some stuff in Senate Bill 163 which talks about, like, the chief judge can do it, and then the chief judge can also do it with a majority of other judges. Ours is streamlined to just say it's a majority, but we don't have heartburn about how the exact mechanism. So ours is just shorter in that regard.
Ms. Travis, on that note, one of the things you told me is your organization agrees that something needs to be done, that we can't just leave the current statute in place, correct?
I'm a realist.
Thank you.
So is my organization.
I appreciate your work on this. Anybody else have a question for Ms. Travis? All right, thank you. One other person signed up to speak on this bill, Wes Taylor with the State Court Judges Council. Mr. Taylor, if you can try to keep it as short as possible for us.
Yes, sir. Thank you all very much. I will just speak on this from a bit of a different perspective, from the state court perspective. I'll initially point out that most of our defendants are not incarcerated when their case is accused. They are usually released on bond after arrest, even if whether they're arrested or not. And I just want to throw out a couple of things. There are only 72 state courts throughout the state. There are 130 judges total. We average 600 new misdemeanor cases every year. Now, what we had at the end of last year, we counted up and we have about 240,000 at the end of last year. So we've been working even through the pandemic. But the issue is, without this bill, we are faced with a potential, as was pointed out, onslaught of speedy trial demands. And if that happens, what will have to happen is there will be DUIs, like 3rd and 10, folks out there who have potentially or allegedly driven under the influence of alcohol and put folks at risk multiple times. There will be theft cases. There will be domestic violence cases that we will have to dismiss, not because we want to, and not because we're not working, and not because we're not trying to get it all done. But there will be those, and so we just ask that you consider this, and in whatever form it is at the end, because it will be important to the, and I think Judge Brasher put it really well, to the orderly administration of justice, even with those misdemeanor cases. I'm happy to answer any questions.
Any questions? All right, thank you, Judge. Appreciate you.
Thank y'all.
All right, with that, we will hold the remaining bills for the next committee meeting, which will be on Wednesday at 4:45. Thank you all for your patience. Apologize for those that came to have a bill heard we didn't get to yet, but we will get to it on Wednesday. Thank you all very much. We're adjourned.